Morning, everyone. I'm Jackie Dolce, part of the Government Affairs team at the Grand Rapids Chamber, and I'd like to welcome you to this important update regarding the Michigan Supreme Court's decision to overturn the legislature's Adopt and Amend strategy, reinstating the adopted 2018 Citizens Initiative for paid sick leave and minimum wage. We know there is a lot of interest and concern around this ruling, as evidenced by the number of people on this call. It marks a major change in Michigan's labor laws, and the results are significant. A higher minimum wage, the elimination of the tip credit, and expanded paid leave. With so much to unpack, we've asked Olivia Lanctot, a business and real estate attorney at Smith Haughey Rice Roegge, to break it down for us. Prior to joining SHRR, Olivia gained experience in business consulting, tax abatements and incentives, and real estate transactions while working for an economic development organization. She possesses a diverse skill set for supporting West Michigan companies with an ability to identify opportunities and mitigate risk through her experience and innovative solutions. Olivia is going to walk us through the Supreme Court decision, discuss the impact on employers, the timeline of implementation, and steps our members can take to prepare. So we are going to record this webinar and we'll link it in a follow-up email on our website along with Olivia's slides. Olivia, thank you so much for being here today.
Thank you, Jackie. I'm happy to be here.
I'm going to hand it over to you, and then following your presentation, we'd like to open up the call for any questions our members might have. If anyone has a question for Olivia, you can enter that in the chat, and we will do our best to get to it in the time that we have. If we're unable to answer it in the allotted time, we will follow up with you and hopefully get you the answers you need. Olivia, I'm going to hand it over to you.
Okay, 1 second here, everyone, while I share my screen. All right, and can you see my presentation there? Wonderful. Yes. All right. Thank you for the introduction, Jackie. Good morning, everyone. I'm glad you found the time to join us this morning. As Jackie said, I'm a business and real estate attorney with Smith Haughey Rice Roegge, but prior to this, I worked with employers of all kinds in Michigan, helping with expansion and retention initiatives. And so with those two worlds of mine colliding, I've found this to be a very interesting decision from the court. Kind of coming at it with an ability to understand it from the legal perspective, but more importantly, what a legal decision like this might look like in action for an employer. That said, we have a lot to cover, so I'm going to get into it. All right, here we go. All right. So here's the agenda of what we'll cover quickly. I'm going to go over the decision, the history of how we got here. Don't worry, not too deep on the history. Well, maybe impacts. Well, how are we going to feel this? When are we going to feel this? And then maybe what we should be doing to prepare for it. So starting off, let's kick it right off. I'm not going to bury the lead. Here is the decision. This is what came down on Wednesday. The Michigan Supreme Court, it was a tight decision, 4-3, found the acts of the previous courts unconstitutional. And so, but what was unconstitutional? The court did not actually give an opinion on the contents of the acts, but rather the way they came to be. So really quickly, I'm going to tell you about the initiative process so you have a base for what we're talking about. Stems back to the early 1900s at a time where it was really hard to get a cause to the forefront. Getting attention of the legislature was really hard for citizens. They found slow actions, and the actions that were taken were not always actually important to people. So in the 60s, the initiative process comes out. And this is a citizen or a group of citizens may attempt to get a question on the ballot for one of 3 purposes. And those purposes include enacting or amending laws. So in order to exercise this right, a citizen or group must secure on petitions through signatures. We've all seen those people at the farmers market. They're looking for 8% of the cast votes from the last gubernatorial election. So a little light base of what it even takes to get it in front of the legislature. So if secured, it goes there, and we'll talk about what happens there in a bit. But that's the process in a nutshell, and a little history information on how these acts even came into existence. So let's get into some more relevant history, which is, of course, the 2018 ballot initiative that was decided just this week, just a mere 6 years later. So the 2018 ballot initiative, advocacy groups circled petitions to raise the state minimum wage and enact a paid sick time. The groups that brought these forward were the One Fair Wage group and Time to Care. Both of those represent restaurant and service workers. They proposed hikes to minimum wage and tipped wage and established an Earned Sick Time Act. Both of these were pretty aggressive. And if I may interject a little opinion here, I suspect this is because the two groups anticipated a lot of negotiation on this matter. It's not something that's ever gone easily or lightly. These aggressive acts left them room to work. But they both gained the support they needed through the signature process we talked about, and they were submitted to the legislature. Even more recent history. So they adopt it. And remember I said we'd come back to the legislature's role in this initiative here. Well, we're already here. We're back. So from here, the legislature has three options once that initiative comes to their hands. They can adopt it as is, they can reject it and send it to the people at the polls, or they can amend it and send both the original option and the amended option to people at the polls. Important to note here, if the legislature sends it to the polls, if they want to make future changes to those acts, it takes a supermajority or a 75% approval rate to make those changes. As we've all been inundated with political partisan stories and living in that world these days, we all know how hard that could be. So before Michigan went to the polls to vote on the initiative, the legislature decided to adopt it in September of 2018, these two acts. You might say that's kind of weird, an aggressive act that's only been approved by 8% of the people through signature collection. That doesn't sound something like a prudent legislature should just adopt. And I would say you're right. So let's go a little deeper. So amendment, adoption, and then amendment. And so after the election in November, the same legislature, and importantly, in the same legislative session, amend both of these laws. And as you remember, the legislature has three options with a ballot initiative. This comes from the Michigan Constitution, specifically Article 2, Section 9, if ever anybody wants to do a little reading, a little education. But so now this is really the meat of the case we have in front of us. This is where differing interpretations, differing minds created a bit of a mess, and that mess made it to the Supreme Court. So the idea is the legislature at the time was, if the Constitution is silent on something, the power is left to the legislature. This is not unusual, but it can be quite ambiguous. So the argument was, and in 2018, it was bolstered by the opinion of the AG at the time, that if there is nothing prohibiting the legislature from taking action in the Constitution, they can go ahead and do it. So nothing in there specifically says after it's adopted that you can't immediately amend it. So this is a big deal. And they also had another factor on their side. They did not send it to the polls, so they don't need that supermajority of 75% approval. They can just go with the classic majority. So if they want to approve it, they only need 50%. So later that year during the lame duck session, the act was amended with a simple majority, much easier. So you are probably thinking, and so were these advocacy groups, can they do that? Why hasn't this happened with other initiatives? So we're back at our meeting question. Did the legislature create this new fourth option to the specified three options, or was this option in the legislature's hands all along because it did not specifically address an adopt and amend strategy? So what it comes down to is when it ends up at the court, they're going to look and see if there's an undue burden. And this is not the undue burden of the actual act, who it's going to affect, the people, the citizens, anything like that. The undue burden that they're looking at is on the intent of the citizens who signed the petition, is what we have in our hands, what they intended to adopt. And so the court says, yes, it does burden that. No, it doesn't burden that. And then we hold because we have some questions to answer. So there we have our dense history in front of us. I apologize if I got too deep. It was brutal, but it was necessary. Let's see how it'll affect future efforts. So, all right, something simple, something easy. This is what it looks like today. You're probably all intimately familiar with this as it affects you currently. And this is what is still in effect even after the decision on Wednesday. So here are the differences. We're going to start, as far as these acts go, I'm going to start with wages because it's kind of a simple and clean left and right comparison here. And so you can see on the left side of the screen, this is the original 2018 Act. On the right side of the screen, this is what the amended version looked like. So you'll see, in fact, over on the left side, if you go to the 2023, it says 1033. That's what we're currently at. That's what we're currently working within. That DCY, it just stands for during calendar year. That's the model they were using. So the amended reduced each increase and reduce the timing for each increase. There's an 8-year difference from the first column to the second column before we reach that $12 an hour minimum wage. After that, we depend on the state to ensure an annual increase is based on inflation. And so now let's go to the tipped wage side, and you'll see some drastic changes here. By 2024, if we had started the process in 2018, there would be no more tipped wage. We would already be there. We'd be at 100% of the minimum wage. As it is now in the still enacted amended act, there was no plan to change the percentage, just have it raised with the planned increases. And then down there under the future, you'll see the Wage Act, state treasurer to increase with minimum wage according to inflation. That would be because the tipped wage would be abolished at that point as they were equal. And then the amended version would add 23 cents per year, just a flat rate planned amount each year. And just a little context, 23 cents on $12 an hour is just under 2% increase per year. Of course, then it would change with percentages, but that's where we go. So I want to take a minute here and loop back. If it was 2018 and everything went into effect at that time, the minimum wage increase would probably have a bigger impact. But as it is, we've all lived through 2020 and the economic effects since then. Many employers are now offering their wages in excess of that future minimum wage of $12 an hour. And even with annual inflation increases, it would be a long time before the minimum wage and the wages currently offered even match. So where we're really going to see the impact of this is on the tipped wage category. 6 years after this goes into effect, so 6 years after this new decision, employers of tipped employees are going to be paying their employees a 60% plus increase on each of those employees' base salaries. I don't know if you guys have heard this, but restaurants don't have enormous margins. Between inflation of ingredients and everything else under the sun, the margins have gotten even tighter. So later when we talk about impacts, really they're going to be targeted here. This is where we're going to see a lot of it. So, and again, I don't believe I'm telling you guys anything new there. But moving on, The next off is the time off side of the Wage Act. These provisions were not really gutted in the same way as the wage section of the original initiative. So this is a spelled out version of the act, which it will be the prevailing act. For every hour of overtime a person works, in lieu of compensation, the employee can accrue 1.5 hours of comp time. Can be used for any purpose. I would say this is the typical definition of comp time. Down at the bottom, though, note those conversions. Employees can hold that comp time, say, I want comp time, and then later ask you to convert it back to wages. That's a complicated accounting function right there. And then employees can also convert compensation, comp time to compensation at point of termination. So that's another tricky accounting function that you're going to have to keep in the back of your mind, because really these decisions could be made at the discretion of the employee. So factors into heightened tracking requirements that will be imposed on employers. So next act, this is the Earned Sick Time Leave Act. It's a bit different from the Paid Medical Leave Act. That's the amended version and what is currently in place. So I'm going to start off with telling you about the earned sick time, and then I'm still going to tell you about PMLA, which is in effect now, mostly just to highlight the differences and what we're working with now and what you're going to have to be prepared with. So as you can see, this also opens up benefits to entirely new categories of employees that normally would not have been able to access something like this. So again, many companies have already passed compensation and benefits packages through this. So it's, again, going to be a lot of those hourly workers, tipped workers that are suddenly having new access to these types of benefits. So, and this is, ESTA is really broad reaching. It's any employee, and if they meet these requirements of working 30 hours within a week, they're going to earn that 1 hour of sick time, no matter who they are. So it's uncapped, but limited to using 72 hours annually. Like I said, no exempt employees. These are temps, part-time, causal, collective bargaining. These people are going to be able to access these benefits. So, you know, why would you bargain if you already have this? Maybe it makes it easier in the future, but right now this is going to be something you have to account for on your own. Also, under this, the reasons people can use this have expanded, not just physical health, all mental health, and then also expands on the family members who a person can take this off on behalf of. So includes domestic partners, and in some cases, even people with an association to employee that they could say equates to a family member. So, you know, somebody that they've taken care of for a long time that's not a blood relative. There's going to be people able to make those arguments. And going back to the expanded use, if the employee or their family member, including the extended version of family member, is in a domestic violence situation or a sexual assault situation, the requirements that come after something like that also can be folded into this sick time. So that's counseling appointments, doctor's appointments, court dates, school visits if it's their minor child. So it's really going to expand the time off that an employee can take. There is a small business exception, a little carve out here. If you have less than 10 employees, you're only required to give them 40 hours of that time, but that's paid, and you can allow 32 more unpaid. Of course, you can allow more than that, but that is the minimum. Another big thing here, you're going to have to keep measure the increments of their time used in the smallest increment otherwise available on how you keep their payroll. So if you know, here at our firm, they measure my time in 6-minute increments. If they had to measure my time off in 6-minute increments, again, a really sophisticated accounting and payroll function. So, you're going to be looking at what are your increments? Are they 15 minutes? Are they on the hour, half hour? Are they 6 minutes? Those are the same increments that you'll have to be tracking this time on. So, and one more thing that I highlight later, but I think I should mention it now. A big part of ESTA is it puts a lot of the burden back onto the employer. There is this, it prohibits retaliation against employees who exercise their rights under this act. It gives employees 3 years to file civil actions against their employer for alleged violations. And the fact that they make an allegation, there's a rebuttable presumption that it has happened. So the employee does not have to prove it did happen, rather the employer will have to prove it did not happen. It's a big shift in the burden. So that's going to be something to take care of. We'll talk more about that on the preparation side, but that's going to be a big deal. So here's the Paid Medical Leave Act. This has been in effect since March 29th, 2019. Again, just have this up here to highlight the differences. This is where the legislature carved out a lot of exceptions. Again, I believe it's because there was broad strokes in there, because I think the original advocacy groups expected to have some negotiations, some back and forth, or expect some amendments from the legislature. So in this act, the groups that didn't have to abide by ESTA, employees who work less than 25 weeks a year, those classic exempt professionals, trainees under 18, those under those collective bargaining or agreements through unions, employers with less than 50 employees. And so the fact that these are specifically outlined in the Paid Medical Leave Act just kind of highlights what a broad brushstroke the ESTA covers. So it's really, nobody is excluded under that. And also changes in this one, the 1 hour of sick time was per 35 hours, and there was an accrual cap at 40, a use cap at 40, and employers were allowed to create notice and request policies. They probably can still do that, but this was something that was specifically noted in the amended version. So moving on, this is, I think, why a lot of you are here. What's this gonna do to me? What does this mean? One, I started here, impacts on current employer required programs. I highlighted 2 of the biggies. I had one question earlier this week on if this would replace any programs. So we've got FMLA and FLSA. Both of these are federal programs, and all federal programs will still exist. States can then create stronger or better protections on top of federal programs, but these will always be in place and apply to everyone. So, but as you see, FMLA is for 50+ employees. With ESTA, again, we talked about that more extensive list of illnesses, the wider range of families. It's only 1 week per year that can be used. So if people are using FMLA, that's that 12 weeks that people can petition for. It's unpaid. ESTA requires 40 employers to offer 40 hours, which is 1 week per year, the paid. So people could potentially use those in conjunction. There's some verbiage in the act that if people are asking for more than 3 days in a row off, you can ask for proof of illness or anything along those lines. So there are a few employer protections in there, but these could potentially be used in conjunction if allowed. FLSA, this is the Wage Act. This is where we see FLSA does not cover those in those exempt category. Again, there's no exempt categories in these new acts. So the Wage Act time and a half versus those comp days, depending on your specific situation, what you currently offer people, you may have new people earning comp days or that time and a half. And so this is something you're going to have to look into. This is something you would have to assess on a company by company basis on your current situation. So if you have the resources at hand, I would ask your own legal counsel for a personal assessment, or if you have HR and they've had a chance to get up to speed on this act, ask them, hey, how does our specific situation line up with this? That would be, I don't think there's any blanket answer to that one. And so then other impacts on your business, these are more of the day-to-day kind, less of how they conflict with other policies that you already have to conform with. So here's some things we should discuss. And again, when I mentioned earlier that tipped wage is where it's really going to come in, this is where. So reduction in workforce. A recent Michigan Restaurant Association poll showed up to 25% of restaurants indicated they would have to reduce their workforce if there was an increase to minimum wage. This is going to impact how you do scheduling. This is going to impact morale. This is going to impact budgets and wages, losing people. Everybody knows it's hard when that other bartender doesn't show up for their shift. More than anything, it can just really shift a culture. And that's hard on top of the monetary reality of everything. So, and 25% of restaurants, I'm not sure how many restaurants are in the state off the top of my head, but I do know that there are almost 500,000 restaurant workers in the state. So, you know, imagine having 25% less restaurant workers. You're going to be waiting a while for burgers and everyone's going to be unhappy. So that's something to keep in mind. How are we going to is there a way we can find to keep on more people? Is there a way to incentivize people, you know, especially as they have more ability to take flexible time off that you're also paying for? How are we going to manage that? And so these managing requirements, improve systems, processes are going to be really, really important. Tracking time off, tracking increased expenses, tracking how they impact your bottom line is going to be a diligent task that should be done. Otherwise, you will get lost in these acts. You will get buried. Are you going to have to bring on new staff for that? A lot of people don't have in-house HR, in-house payroll, things like that. What's this going to mean for your systems, your processes, your staff? And then going back here, this termination is the rebuttable presumption. This is what I kind of got into a bit earlier. If there's a violation and there's a termination with 90 days of time taking off, this rebuttable presumption exists. So again, if there's a claim, there's nothing up to the employee to prove it, but the employer to disprove it. Changes the burden a lot less on the employee, a lot more on the employer, on top of all the other new impacts that you're going to manage. So this goes back to having good documentation. You're going to want to develop clear policies on surrounding the ESTA in particular. Clear policies, processes in place, documentation, better systems, support staff if you can swing it, and support programs otherwise. Support programs either being technology or, you know, small business resources, something like that. And then, so on top of that, so we have the impacts to the business, but then also potential outcomes. What's going to happen now? I mean, we've already seen this go through once. So are there going to be actions to block this, block these changes? No, this has gone through the Supreme Court. This is what it is. But are we dead in the water? No, of course, we're going to have new ballot initiatives and legislature coming up almost immediately. And well, we've already enacted this one, so I would say it's impossible to roll anything back. There will be new initiatives that can amend it. Remember how we got here in the first place. An act can be amended, just make sure you do it right. So this is people who are involved in committees and those action groups and everything, make sure you're taking the right actions and make sure those who are enacting them on behalf of you know the outcome. So that's why I took you through the history earlier. So many of you are active participants, influencers in these industries. If you don't really stick to the processes outlined on the legal side, you can shoot yourself in the foot and put everybody and industry a whole in a real pickle. And so knowing how that process works, we know that we can amend these types of things. It's just going to be harder. And then also, that amendments, new ballot initiatives could even make this act moot before we even get through those 6 years. I mean, we've already seen one ballot initiative. It was actually from the same advocacy group, One Wage, advocating for $15 an hour. It was struck down, but that was really it was struck down. Again, the courts don't like to rule on content of these acts, but they did find a reporting error and a recording error in the act. Half of the ballots said it would affect employers with 1 or more employee. The other half said it would affect 21 or more. So really, people are already coming for this. That friction will always be there, but make sure your advocacy groups and your representatives know how that could play out, because this is a really, I mean, we saw it took 6 years. Business moves a lot faster than that. We don't want to be waiting again if employers want to see a change to this. So this is the timeline of what it really looks like. Again, a little piece of legal influence here. The original act gave employers 205 days to implement measures, processes to adjust for the changes. They're going to leave that in place, and they are giving everybody 205 days from Wednesday before these take place. So we talked about the inflation adjustment. So the original one was $10 going up to $12 after 6 years. So we're going to add inflation on top of those original numbers, and those will be the base margins. So by November of this year, the state treasurer will determine what those original amount inflation numbers look like. Then February of next year, everything goes into act, and we'll have to start adjusting our payroll based on these dates right here. We're basing everything on February 21st, 2025 through 2029 and thereon after. So that's what the timeline looks like. How are we going to prepare for this? I've been kind of sprinkling it throughout here, but really you're going to want to sit down right now and identify all your employees, their current wage rates, and against, what your policies and processes are, what your positions look like, and determine what needs to be modified, who needs to be modified, and where. You're going to want to assess those short and long-term budgets. Again, this is going to totally erase tipped wage. So long-term budgets, what are you paying off right now that this could eat into those costs? I mean, maybe you've got new kitchen, maybe you've got new property within there. Do you have enough employees where this is going to eat into your ability to pay those off? What does that look like? Make sure you can be in compliance within that timeline. In those budget analysis, don't forget to project for paid time off and project for sick time. If you already know, if you've had staff for a long time and you can kind of track how often people are sick, you've heard rumblings of how they would like to take their time off. I mean, maybe sitting down with your employees and having a frank conversation, it would be a good place to start. I know it's hard to go that route, but you don't want to you could feel like you're getting railroaded, but that wouldn't be the case. It would probably just help to give an accurate picture of what's to come, what people really expect from this. Again, if applicable, if possible, include a CPA or HR teams in these assessments. See what your systems look like. Are they capable of handling these changes for you? Otherwise, you're going to get bogged down in minutia and not be able to run your business. And that might be how we lose some really good businesses. So with that, I've said a lot already. So I'm going to open it up to you folks online. Do you have any questions for me?
Olivia, we have quite a few questions coming in.
Okay.
Our first question asks, does the ESTA cover both exempt and non-exempt employees?
From this initial ruling, yes, so far.
All right. Second question. Is there any legal challenge to requirement of typical earnings to be paid based upon the prior pay period? In specific, for tipped earners, as tips belong to employees under federal law and are not held by the employers?
I'm not really sure how to answer that question. I don't know if whoever sent that to you wants to, my email is at the end of this presentation. I'd be happy to look into it a little bit more. Here, I'll flip it up right now. If you wanted to email me, I might not have the answer to that, but I would be happy to check to see if there is any sort of, and if we've seen any action in that sense so far, but I don't know at this point.
And we'll collect them.
And we're going to collect those questions as well. Here's another one. What happens when we terminate seasonal or temp employees and then retire? Rehire? Do they keep past earned sick time?
That is a great question. Sick time, it's able to be rolled over annually, but that information is based not on a seasonal or temp type worker. That information is based on continuous employment. So I'm sure there's something in the 105-page decision. And so I'm sorry, again, I don't have that question off the top of my head, but it is a very interesting question and something I'd be interested in looking at. Especially, and then as you mentioned that, even more categories of workers, you know, underage workers, impaired workers, what does it look like for them? But yeah, the actual, you know, it's a full layoff, is it a termination? I'm not sure what it looks like for that individual business, but yes, that continuity could be an issue there, and maybe rollover doesn't exist. So great question.
Is front-loading time no longer acceptable? Can ESTA be combined with vacation time, or will there be requirements to separate these?
So ESTA, that's specifically for the sick time. As far as combining that with vacation time, if somebody's, I briefly mentioned it earlier, if somebody is asking for extended time off or sickness or anything like that, you can ask for documentation as far as the what it's about. But if they're using their paid time off for sickness, then I believe, yes, those could be used in conjunction.
Can an employer require that an employee be compensated for the overtime, 1.5 hours per 1 hour worked? Or does the employee have a choice to receive comp time?
As it reads, as I understand it, the employee has the choice.
Are you allowed to keep a 30-day waiting period to allow access to sick time, or is it immediately available after 30 hours of work?
That is another great question. I'm so sorry to have that answer to so many. That is a really good question. There was not language on these sections I read for that. There could be language in there. Again, I would be happy to briefly look into that and answer that question if that individual would like to reach out. And I'm not sure if we have this ability, but if you'd like, I'm sure other people have the same questions. I mean, any answers I come back with, I'll share them with Jackie. And if you have a way to disseminate information, I'm happy to tag on to that.
Right, we will do that.
Mm-hmm.
Do you think it is possible for employees that don't use the new sick time to allow them to convert that into PTO and reducing the sick time equal amount? This way we could have PTO earned and you get PTO because you didn't use your sick time.
Could you say that again?
Sure. The question is, do you think it is possible for employees that don't use the new sick time to allow them to convert that into PTO and reducing the sick time equal amount? This way, we could lower PTO earned and you get PTO because you didn't use your sick time.
That is an interesting way to look at it. And I did not see anything requiring employers to allow that to happen, but if that's something they want to do, that it could possibly be an individual business's choice. That's something to look into again.
What about contracted employees through a temp service? And then lots of questions about independent contractors as well.
Again, this is going to be probably where legal worlds, CPA worlds, HR worlds combine. It's going to depend on, most likely it's going to depend on where is the pay coming from, who is this person contributed to. Independent contractor world gets a little dicey, so it potentially could apply to those people. It could apply to temps. We'll have to see where temp services come down and what burden they take on versus the employer. So that I believe needs a little more time to shake out.
Okay. If an employee uses sick time, do employers have the ability to require a doctor's note? Can you explain that process?
I'm not really sure on the details of that process. There's no, as of this moment, Michigan required standard of that process. I just know that there was language within the act that there is a way that an employer can add that into their policy, that if people are taking off, more than 3 days for a singular illness, they can ask why, or request information.
All right. Can you explain sick leave capped or used annually? Like define annually?
Yeah, annually, I guess it would be whatever, however, whether you're running calendar year, fiscal year, hire date, that would be the annual, that would be the calendar. So capped at 40 means what the employer's required to offer. So the cap is for the employer. You only have to offer 40 a year. Under, I forget what that threshold I said earlier was. You can offer 32 more unpaid. You can obviously go beyond that or pay those 32 hours. Over whatever that threshold was, the number is greater, but the cap is capped time that they can take, capped time the employer has to let them take, but the earning potential is continuous. So why doesn't that align? That's looking forward to if someone has an extended illness. They've been working for you 15 years. They get the full rollover every year. All of a sudden they have this big bank of time off and they've got an illness and they're using it here, using it there to help take care of things. They've got it stashed away. So big accruals, but less requirements for annual usage. Protection from abuse of that right.
Okay. Does this now impact all employees versus the PMLA, which impacted those that worked on average 25 or more hours?
From the verbiage in there and the lack of exceptions within it, that's how it reads.
Okay. How long do employees have to change their mind about initially choosing comp time for overtime and then deciding to get paid? Can it be required that this is decided in a given time period or in a fiscal year?
Ooh, and yeah, that's going to be that tricky new accounting and payroll and tracking process. I don't know. I mean, if I had to dive into it deeper, I would suspect annual, but I don't know. There might not be a regulation on that. I don't know what time frame that they have to make that decision, and how an employer would account for it. What kind of reserves you have to have. That will be very tricky. That may be more of a CPA question. I'm not totally sure on how that will work.
Can interns earn sick time?
Great question. I would say yes. I would say if they're working for you 30 hours a week, they'll earn that 1 hour of sick time. But again, that's speculation. So like I said, please email me. I can dive into things deeper. These are my initial thoughts from reading everything that they came down with on Wednesday.
All right. Any other questions coming in, Marcus?
Yes.
Yeah. Oh, more questions, Olivia. Marcus is getting the questions to me as we speak.
Okay.
If they don't use it, what do you have to pay out upon termination?
The same rate at which they earned that time. So, if they've been there a while, that might be, again, some complicated calculations. They might have earned some of that time at a lower rate, some of that time at a higher rate, but you have to pay out and not time and a half or anything like that, not the comp time, just the hourly wage that they earned it at.
Is there any way that this will be overturned somehow?
No, I don't believe that will happen. But again, sections could become moot if other legislation goes through and is the controlling legislature or controlling legislation, or you could still propose amendments to this, but it would go through that process again and need that 75% vote. So there could be changes to it, but there's nothing that's going to cancel this outright.
Last question, Olivia.
Mm-hmm.
We currently pay out any unused PTO each January. Can we still do this with ESTA, or do we have to allow them to accrue and roll over these hours now?
So ESTA will not affect the PTO, that's the sick time. And so, yeah, PTO payout, that seems to not be affected by this. They would still be able to roll over their specific sick time ESTA hours, but not PTO under that act.
Last one.
What's that?
You want to resolve
Sure.
questions? Does a week of PTO earn sick time?
Does a week of PTO earn sick time?
I guess in what sense? Or do we have more information?
Like if you're on vacation using PTO, are you still accruing sick time?
No, it's hours worked. So it's
Okay.
it's not you can't double dip in that sense.
All right. Olivia, thank you so much
Yes.
for joining us today and for walking us through this ruling. It's so important, and it's important for our members to hear this information, so we really appreciate your help. I am going to turn it over now to Josh Lunger, our Vice President of Government Affairs, who's going to share with you some of the things that we're doing behind the scenes on behalf of our members in the business community.
Thanks, Jackie. Sorry, we're switching. We can do more than one thing at a time sometimes. Yes, I would say based on the level of interest and all the questions in today, it's safe to say that this issue has jumped to the top of our burning fires list in Lansing. We knew this decision was coming. We had a general expectation of what it would entail based on the court case. And that being said, it's still very, very, very concerning. And we've heard, particularly from those in the small business community, the service industry, particularly restaurants and those with employees earning tipped wages, and those employees themselves, that they want to see clarity and certainty here. So we have been having, I would say, more than daily conversations with our allies across the state. We have meetings set with legislative leaders. We have meetings set with executive office, and some of the things that were asked of Olivia will come down to how the state departments interpret and plan to look at enforcement items. And so we're meeting with the department leadership as well in the next several weeks. And our hope is as we work towards potential changes with the legislature, we want to get your questions. So I know we didn't get to all of the questions today. Our team is tracking them. We're going to work with Olivia and follow up with those that attended the call. You can email Jackie at grandrapids.org. And Jackie, can you put your email in the chat, because you spell your name so uniquely. But there's also other ways to follow along. You can sign up for our newsletters at our website, or our First Friday calls where we talk about what we're working on. I will say that our focus right now is, oh, and Paula asked if it'll be provided in the Spanish. We should try to get that done. Thank you, Paula. We're trying to keep the business community together. You know, there's different priorities, like the Michigan restaurants, for example, are more focused on tip wage. Some are worried about quicker elevation of the minimum wage for other service industries that don't have tipped wages. And so our focus is trying to keep all of us together and working with the legislature to mitigate the harm, particularly, again, for small businesses. I know we're hearing a lot about what was talked about today, particularly the tipped wage, and how this earned sick leave will drastically change things for, again, many small employers are rightfully panicking. And so we've placed this at the top of the list, and I promise that we'll be working hard on a daily basis to try to reach some type of compromise with the legislature. That being said, if you haven't noticed, it's an election year, and there is a lot of things that could complicate how and when this gets done, whether this is an urgency item that we try to get done before the election, or whether this is a lame duck issue post-election, is still unknown, but we will do our best to communicate regularly with our membership. And again, you can sign up for our communications. You can connect with Jackie. We want you to tell us what's on your mind or what your concerns are, and we'll do our best to answer any questions individually or as a group. And our hope is to put an FAQ out as we get these questions. We'll work with the departments to see what type of information they're able to access and get out as soon as possible. I do know the governor's office is taking a very direct interest in how this is communicated and how this is interpreted from their departments. So we're not expecting very rapid answers to some of these questions, or maybe as we get more technical, we want to make sure that we're getting those out to you. So again, please email us, please connect with our team and or follow along. And if you're not getting a response, pick up the phone and call us. We want to know what's on your mind. We want to be there to help.